Thank you. Right, I welcome members to the 25th meeting in 2014 of the Delegated Powers and Law Reform Committee and ask members to switch off any mobile phones. We have apologies from Richard Baker, in whose place I welcome Mary Fee. Agenda item 1 is a decision on taking business in private. It is proposed that the committee takes item 6 in private. Item 6 is consideration of the committee's approach to the delegated powers in the Community Empowerment Scotland Bill at stage 1. Does the committee agree to take that in private, please? We do. Thank you very much. Agenda item 2 is the Legal Writings, Counterparts and Delivery Scotland Bill. This item is oral evidence on the Legal Writings, Counterparts and Scotland Bill. Today's session allows us to take evidence from the Law Society of England and Wales, who, along with the City of London Law Society, are responsible for the practice note outlining the modern English law on execution in counterpart, which informed the bill. Joining us via video conference is Warren Gordon, member of the Law Society of England and Wales, Conveyancing and Law Committee, and the head of Real Estate Know-how at Oslang LLP. Can I welcome Mr. Gordon again and invite him to make an opening statement, please, sir?
Yes, well, thank you very much for giving me the opportunity to speak today. As you say, my name is Warren Gordon. I'm Head of Real Estate Know-how at Oslang LLP. We're a law firm in London and with other offices in England and around the world. I'm also a member of the Law Society's Conveyancing and Land Law Committee and will become chair of that committee from September. As a member of the Conveyancing Committee, I have some involvement in the production of the Law Society's practice note in February 2010 on execution of documents by virtual means. My specialism is in the real estate area, and my experience of execution of documents, virtual signings and counterparts is in that context, although I'm happy to comment on its application in other areas. Many thanks again to the committee for being given the opportunity to provide some information to you about our English experiences, which hopefully will be of use to you as you formulate your legislation. So without further ado, perhaps we can take the questions.
Indeed, thank you for that introduction. We'll go slightly slowly because our cameras need to be able to move. And I'd like the first question to come from Margaret McCulloch, please.
Thank you. Good morning, Mr. Gordon. My question is on the background to the English law of counterparts. And I'm wondering if you can actually explain to us the extent to which counterparts are used in commercial settings in England and the role which law firms play in the process.
Thank you very much for the question. So, the doctrine of counterparts in English law has got a couple of meanings which I will explain in my answer. The first one relates to deeds, and counterparts in our interpretation are deeds executed as duplicates or identical documents. So when a deed is executed in duplicate, all the parts are regarded as one deed. So you might have separate parts, but you regard it as one deed. And each part is equally effective. I'm talking here at the moment about written documents as opposed to virtually electronically signed documents, which I'll talk about in a short while. And the concept of the original deed and the counterpart duplicate constituting one deed and each part being equally effective, that legally is at the heart of the English law on counterparts in relation to written documents. Certainly in a real estate property context, which is the one I'm most familiar with. So the biggest example of that would be something like a lease, where the two parts of the lease, the part executed by the landlord and the part executed by the tenant, are identical. So the part of the landlord executed is called the original, or the principal deed, and the part executed by the tenant and the guarantor is called the counterpart. And the counterpart does not have to be signed by all of the parties to be valid. It only has to be signed by the tenant and any guarantor of the tenant. The landlord signs a separate part called the original. And it's this original deed, which is usually the part executed by the party doing the disposal. So I'm guessing this would sort of be similar in a corporate context, but the party who's actually selling the property or letting the property, the one who's carrying out the disposition, as we call it in legal terms, that is always going to be the original document, and that will be the document that, for example, in a land registry context, is sent to the land registry and is registered there. Because the land registry is registering the disposition, and it's the original document that's disposition, so that's what's registered. In terms of the counterpart, the land registry doesn't need to see the counterpart. What the counterpart is doing there is it's effectively evidence that the tenant executed the document, and the landlord could use that counterpart if it wanted to sue the tenant. It would need to have that document to go to court and bring proceedings. So the counterpart does have a role, but ultimately the original prevails over the counterpart. if they're not identical. Now, clearly they should be identical, but sometimes maybe the WP systems don't work properly and they're slightly different. And in that scenario, the part executed by the landlord would prevail as the original over the counterpart. But if, for example, you had perhaps the unlikely scenario of the original document was used, the counterpart still have a role to play in that situation because it could be used as evidence that the document existed. Now, one of the issues that the committee raises is what is the advantage of having an original and a counterpart? There's also, as I come on to, a separate concept of counterparts generally in commercial agreements, which also has advantages, similar advantages. But in a sort of real estate context, having a separate original and counterpart separately executed by the parties, the key benefit, fairly obvious, is that if the parties are executing separate identical parts, it's much quicker. There's a much quicker speed of execution, and that must improve the efficiency of the transaction. If you had to get all of the parties, the landlord, the tenant, the guarantor, to execute both parts of the document, it would slow up the transaction, particularly as we'll come on to, where you're talking about parties that are based overseas. And it might be much more difficult, much more time-consuming, especially if you're executing by a one-time signature, as we call it, to get those documents executed. So an original and a counterpart in a real estate context relating to deeds is a much more effective way of executing documents. It has to be said that sometimes people like all of the parties to execute each part just to make them feel more comfortable, but usually in a property context that doesn't happen. So that's property, but then broadening out a bit to the kind of concept of counterparts, which I think is more applicable to virtual signings and to your bill, commercial agreements. So in commercial agreements, you often have what are called counterparts provisions. There's a clause in the document relating to counterparts. And it is quite similar to what I've just been talking about, although it's slightly different, as you'll see. We don't have a concept of original and counterpart in that context. It's the concept of counterparts. But similar to what I was saying previously, it still means that those counterparts are identical parts of the document. They're exactly the same, but they are signed. Each one is signed by a different party. So you don't have all of the parties signing one document. And signing separate counterparts has the same effect as if all of the signatures on the counterparts had been on one document. So although the parties physically are signing separate documents, legally you treat them together as one document. Each counterpart is an original, which can be taken to court, sued upon, but all of the counterparts together, similar to an original counterpart, constitute one document. Now, why I think this is particularly relevant to the concept of virtual signings, as dealt with in the law practice note, also in relation to your bill, is again it highlights the efficiency of each party being able to do their own electronic and virtual signing, and then ultimately, once all of those have been done, that can constitute together one document. So that flexibility of each party signing by themselves, without everybody having to sign one document, provides a lot greater flexibility, which can be utilised in an electronic virtual signing context. So that is the benefits. Do you have any questions on that at this stage? Because my next comments relate to your question too.
Forgive me, Stuart Stevenson had an observation, please.
Thank you very much, Convener. I've listened carefully to what's said, and I hopefully am understanding that. In particular, I'm looking at a submission the committee has received from the Faculty of Advocates. And the one thing I didn't hear in your contribution, Mr. Gordon, and of course it may be the difference between English and Scottish law that accounts for my not hearing it, and that was the delivery of documents, which is part of our legislation. It seemed to me that you were suggesting that, particularly in relation to property, there was not necessarily a delivery to the primary signer, and I'm using, that's my term, because you clearly made a differentiation between the status of the two versions of the document signed, one in counterparty and one otherwise. Is the junior document, my phrase, actually delivered so there is an opportunity to compare the two and confirm that they are identical? Because you did make mention of any difficulties that would arise were they to be different. Is there a delivery process in what you do?
There is a concept of delivery, but as I understand it, and I'm not an expert on Scots law, one way of delivery in Scots law is to physically deliver the document. Is that right? That concept isn't a necessary corollary of what we do, but in practice what happens is one firm of solicitors produces both documents and then gets the parties to execute, and ultimately one party ends up with each part of the document. And so in terms of them comparing it, the solicitors will check that they are the same, but the physical delivery of it isn't integral to the legal effect. Concept of delivery in English law, as I will come on to on virtual signings, is if a party signs a document under English law, the delivery in our interpretation is that at that point in time, they are legally bound by virtue of the fact that they have signed the document, unless the parties agree otherwise. And normally we agree otherwise. Normally we don't want a party to be bound merely at the point of execution. We say that they will only be bound when the document is dated, and the dating will take place after the respective parties have executed. So this physical concept of delivery binding the parties isn't relevant in English law, but we do have a concept of delivery whereby if a party signs, they will be bound unless the solicitors and the parties agree otherwise, that it will normally be at the date the document is dated.
Do forgive me, I just want to try and be as clear as a lay person can be. The concept of dating in relation to this, the legal effect of the two signed copies only starts when the documents are dated. Now, could you describe how dating happens, who's party to dating, and have there been any cases where the absence of dating or questions around dating have led to difficulties in your jurisdiction, the way you do things?
What happens is the parties execute the documents and they don't want to be legally bound until it is dated. So the documents will be undated, and what will normally happen in my experience of transactions is the respective solicitors will usually speak on the phone and they will agree at a particular point in the day, a specific time, and a date that the document will be dated at that point in time. And from that date, from that time, the parties will be legally bound. So with contracts, which are not under deed, again, they are executed. Because there's no concept of delivery in the concept of non-deeds, the parties aren't necessarily bound at the point they sign. It then goes to the solicitors, and the solicitors at that point use a law society formula to exchange the contracts, and there are various elements of that. And again, being specific, when it is dated, it is from then that the parties are bound. The comparison is with a deed, where there is the danger, as I say, that a party can be bound merely by virtue of the fact that they've signed the document, even if it has not been dated at that point. Now, of course, that could create quite a lot of uncertainty, and for that reason, and I'm not saying every document's like this, but any well-drafted document will have a specific statement that says delivery, as we understand it, takes place on the date of this deed. Therefore, the fact that the parties have signed the document does not mean that they are bound at that point. Because what can happen sometimes is a party may sign something and then they may have second thoughts. They don't want to proceed. So they don't want to, or even they might sign something and there might be a 3-month gap till it's completed. So they sign it, but they're not legally bound until it's dated. And dating, all that means is there's a gap in the front page that says you put the date in and the solicitors agree, this is the date we're going to complete, so where we use complete this deed. Once it's dated, from that moment, the parties are legally bound.
There is a contract, implicit or explicit, between the signatories and the lawyer who is acting on their behalf, because it is the lawyer who is giving effect to the dating.
Correct. The lawyer is in effect acting as the agent of the client to bring effect to the legal completion and the dating.
I'm sorry to be so pernickety, but I'm kind of known for it. So you have, if I understood you correctly, this is a third lawyer who has a responsibility to both sets of parties to the contract. Is that my understanding?
No. So basically, each party, I mean, some parties will sometimes not have a lawyer representing them, in which case we'd advise them to get independent legal advice. But normally, in commercial transactions, each party has its own lawyer. and the lawyers between themselves, no third lawyer involved, just the lawyers to the parties, between themselves, work out the arrangements for exchange, if it's a contract, or for completion, if it's a deed being completed, and they agree between themselves with no other party involved, how and when it's going to be dated.
Thank you, Convener.
Okay, that takes us back to Margaret. Thank you.
Thank you. I can see the advantage of having the opportunity for businesses to actually be able to sign the documents if they live in, or work in different parts of the country or internationally. Is there any other advantages for companies to actually go down this route?
I would say at the moment there's probably a little bit of reluctance and caution on the part of people to actually go down the electronic route. I'll come on to the Land Registry's change of practice and meaning that possibly we can do deeds by virtual signings. But people, I think, still feel slightly uncomfortable with doing transactions virtually. And I make that point really to say that the advantage that I highlighted is probably one of the main, actually only advantages that I can think of at the moment in relation to doing virtual signings. In terms of the concept of different parties executing different parts of the document, that is something that we in English law have been familiar with for decades, if not hundreds of years. So it's not something that we really think of as an advantage. But it is, I have to say, in practice, a bit of a hassle where you can't take advantage of the counterpart arrangement, and you have to get maybe, sometimes on our large commercial transactions, 5 or 6 parties executing the same document. It is a total nightmare. Because people aren't around when you need them to be, and knowing the way that typical commercial transactions go, they've got to be done yesterday, and it is a real disadvantage. So I stress, for me, that is the main advantage. I can't think of any other particularly obvious advantage of separate execution by counterpart and original, but it is an advantage that is well merited, and I think hopefully the benefit of that can be seen in virtual signings.
Okay, thank you. And lastly, any practical difficulties with English law of counterparts, and have you identified any areas where improvements could actually be made?
Well, so this is, I think, coming on to your second question, isn't it? The main disadvantage, I think, is actually arguably a corollary of the main benefit. Since each party executes its own part of the document, if that part is lost, and these things do happen, documents get lost, it can cause problems if it was necessary to use that part, for example, to bring proceedings in court. Clearly, if all the parties had executed each part of the lease, that wouldn't be a problem, because you could then get a certified copy of the document showing both parties having executed from the other party. Having said all of that, in terms of is it a disadvantage? It is quite rare that parties lose their documents. It does happen. But I would say that the rarity of that occurrence doesn't make it a significant enough disadvantage to outweigh the benefits of the efficiencies of having separate execution. Another disadvantage would be, and this, we picked up on this already, is if the documents are not in identical form. Now, in the olden days, before my time, where people used to sort of manuscript scribe these documents together, one could see that as potentially a disadvantage. But with modern technology and IT processing, even with people having different versions of documents, it would be pretty negligent on the part of the solicitor producing the counterpart and original or the counterpart documents for them not to be in identical form. So I think that, and actually there's an argument even to say that, let's say you had counterparts where you were getting all the parties to execute each part, but let's say the 2 parts themselves, or you execute it, because if you're getting 3 parties to execute each part, it stands to reason that you'll have 3 documents because you'll want each party to have 1 copy. Let's say when they came to the IT processing that the 3 parts were not identical between themselves. So even if you're executing with all parties executing each part, you've always got the danger that if you've got more than 1 copy of that document, that the documents could be different between themselves. So the concern about not being in identical form is, I put forward simply because you've asked me for disadvantages of it, although in practice with IT, it shouldn't be an issue, because what you're doing is you're literally pushing the print button and saying, I have 2 copies of that, please. It's not like you're having to go through any different process to create the second version of it. So if one is concerned about that, one will be concerned about knocking out more than 1 copy of any document when you push the print button. As I say, I think these are disadvantages, but they are so minor and they are outweighed by the greater efficiencies we have by executing separately.
Okay. Thank you very much.
Right, thank you very much on that. And that takes us back to Stuart Stevenson, who I think perhaps has a point on that before he moves on.
Yes, I just wanted to ask whether consideration being given to the use of electronic signatures that relate to the document. In other words, validate that the document is a particular version and that therefore allowed quite quick comparison of electronic signatures rather than having to dot by dot, cross T by cross T, compare the detail.
Okay, I'm not aware of that, certainly in a real estate context, and I personally, I think it's probably unnecessary. We have, throughout, a lot of the documents are negotiated online, you have different versions. When a version is agreed and it's ready to push the button to engross that document, then clearly the solicitors for each party should be looking at the final version. A final version should be circulated to the respective solicitors, and the solicitor then comes back and says, I'm happy with that document. The lawyer who is producing, one of the lawyers will produce the final form of the document, will physically or email the document to the other side. Any lawyer doing their job properly will then check the document. I use a tool here in the office called PDF comparison, which can do, it's a technical device which shows any differences between the two. I agree with you that effectively locking down the agreement by an electronic signature, it's funny, we're going to come on to that, of course, on later questions. But in terms of this context, yes, it probably would be a more effective way to do it. But it, I'm guessing, will probably be more administrative, probably more costly. You'd have to have the solicitors liaising between themselves. Will there be any incompatibility in the technology between the respective solicitors? And I think my answer to your question is, I think that the technology that we have at the moment gives sufficient protection to solicitors and their clients, bearing in mind the cost pressures on transactions, what clients are prepared to pay in the real world, what firms are prepared to spend, what they can afford to spend. They're going to do things that they need to do. And if the technology here is sufficient to protect them to a reasonable degree, then I think people will perceive that to be enough.
Right. I'm available on consultancy at about 1,000 a day, so there we are. Anyway, let me just move on to the Mercury case and the Law Society's practice note, which your introductory remarks indicated you were party to. And I just wonder if you could tell us to what extent you're satisfied that the practice note addressed the issues that was raised by the Mercury versus HMRC case.
I think that, this was a case from 2008 that I'm sure the committee is aware of. It was a case, as often happens with these kind of cases, that was very specific to its particular facts. And in that sense, you could say, well, it wasn't that significant. But it was important because it highlighted areas that perhaps the profession hadn't focused on closely enough in relation to pre-signed signature pages and also the whole practice of contracts being exchanged by signature pages being exchanged by email. So particularly in a commercial context, and actually to a degree in residential context with increasing numbers of overseas purchasers, we have lots of people who are abroad who we act for, and it is too fiddly to send an overnighter to somebody to get it signed with wet ink and then send it back. And lawyers have always been attempting to come up with their own solutions as to how they can go about trying to effect an exchange legally that would properly bind the parties. And there was great uncertainty, really, about how they go about doing this and whether the clients would be properly protected in that situation. So the Mercury case was not of great relevance to what practitioners do, but it highlighted that there was an issue that the Law Society needed to address in its guidance. And it wasn't only, as you say, the Law Society, it was also the City of London Law Society that was involved, arguably particularly that society, because a lot of its clients involved transactions overseas. So we have this guidance, which was in the practice note, and my particular interest obviously was in relation to real estate documents and deeds. And what the Law Society came up with were three options, as you're probably aware. Is the committee fully au fait with the contents of that practice note, or shall I reiterate the key points on the three options?
We may know as much as we need to, but if you can briefly just point to a few bullet points, I would be better informed.
Okay. So just a couple of introductory points. As I say, virtual signings mainly occur in a property context in relation to real estate contracts. So in English law, we have a contract, which is usually a contract, which is the agreement to sell the land. And then at a subsequent point, usually, there will be the disposition, the actual transfer of the legal interest. Virtual signings normally occur in a real estate context in relation to contracts to sell. So it will be at that point where the parties are initially bound to transfer the property at a later date. And the urgency usually arises where the clients want to get the contractual commitment. The legal transfer itself will happen later, but the urgency is getting that contractual commitment, and that's why they need to do an electronic signing. So it's normally property sale contracts. So up to recently, the dispositions themselves, the transfer of the legal interest, we would never do by virtual signings. And the key reason for that was these dispositions had to be registered at the English Land Registry. And the English Land Registry, up to about 2 months ago, required wet ink signatures. So they wouldn't be happy with a PDF copy. They needed a wet ink signature. However, from the 30th of June, the Land Registry has changed its practice now, and it no longer wants to see original documents unless it's a first registration situation. So for the vast majority of property transfers, the Land Registry does not need to see the original document. Now, I don't know what the practice of the Land Registry of Scotland is, but it's quite an interesting practice. And actually, what's very interesting about it is it opens up virtual signings to a much wider group of documents, because now it not only includes the contracts, but it also includes the transfers, the leases, and any other disposals. Why this is all relevant to the options is, of course, it means that these options can be much more widely used, and it's very helpful for practitioners to have the guidance. So in terms of the options, there are 3. The strictest option, which is option 1, relates to deeds, because deeds have the greatest technical requirements under the Law of Property Miscellaneous Provisions Act 1989 in England, and also real estate contracts, which again have technical requirements. Documents like guarantees and simple contracts have less strict requirements, and options 2 and 3 deal with that, and I'll come on to those in a short while. Now, each option contains a series of steps that need to be taken by the clients, the parties, and by their solicitors. I'm not going to go through all of the steps for all 3 options, you'll be delighted to know. But what I will do is I'll go through the main options for the main steps for option 1, and then highlight to you the 2 or 3 small changes for options 2 and 3. So with option 1, which I remind you is for deeds and real estate contracts. So any document is a deed, and I think in your context, most of the documents you seem to be talking about are deeds. The parties' solicitors have to agree the arrangements, which is what you would expect for the virtual signing. What then happens is the document is agreed, it's finalised between the parties, and the person who is controlling the production of documents, in the same way that if it was a paper completion, as I mentioned, a solicitor will produce physically the paper documents. So in this scenario, that same solicitor will email to the parties overseas the final version of the document, as we discussed, not PKI or digital signature protected, but still the final version of the document the parties have agreed, and separately a signature page. And this is emailed to parties overseas or to parties who cannot get around to being able to give a wet ink signature. The reason why we have a separate signature page is, let's say you've got a client lying on a beach in south of France, and you've got a 500-page document and a 1-page signature page. In theory, you might say, well, this person has to have a good printer to print out his 500-page document and a signature page, sign it all, and then scan it all back. We think in practice that quite often clients are not going to want to print out lengthy documents, but all we're requiring them to do is to print out the signature page, to then sign with a wet ink signature, the signature page. They then need to have a handy scan somewhere near them, so they can then scan that signature page onto the system, and they then email back to the solicitor the scanned signature page plus that final version of the document. Now, immediately you can see perhaps a slight wartiness, because it's depending on the client attaching the right document. Let's say, for example, they managed to scan on correctly the signed page, but then they go to the wrong email and attach a previous version of the document. So the solicitor controlling the whole arrangement receives back from one party the scanned signature, but version 4 of the document. The other party, has done it correctly, sends back the scanned signature in version 5, you've got a problem, haven't you? Because if you've got documents in a different form, you won't have a contract. You won't have a legally binding document. So somebody somewhere has got to make sure that those documents match. Comes back to your point. To what extent could we have some kind of certification to make the process more foolproof? But the danger is you are depending on a layperson client to get it right in terms of doing what they have to do, printing out the page, signing it, scanning it, together with the document that they were sent by the solicitor. It's not very difficult from a technical perspective, even for people who are not into IT. But you can still see that there's that potential issue that if they mess it up and send the wrong version of the document back with the scanned signature page, you could have a problem in terms of achieving legal effect, unless that's picked up by one of the solicitors. Have you got any points on that at this stage?
Let me just develop a little point from that. You clearly are discussing the legal link between the signed page, pre-signed in some cases, and the document. How is that legal link created? Because it sounded to a layperson a little haphazard potentially. And has that been tested by any case law thus far?
So what we did following Mercury was, as I said, we had to produce some guidance, and we were concerned about the legal links, as you say, about how, does this stack up in terms of English law? I'm not aware of there being any recent cases testing whether a virtually signed document in this format works as a matter of English law. What we did at the time, the City of London Law Society and the Law Society, was what we do whenever we've got a very, very, very difficult legal point, and it's fairly novel, is we go to very senior counsel. So we went to a chap called Mark Hapgood, who gave a very big opinion on that, and we, through the City of London Law Society Real Estate Committee, were concerned about the specific technical issues for real estate documents and deeds. So we went to our own couple of counsel, very senior counsel, one of whom actually, I think, co-wrote the Land Registration Act 2002, so he's fairly knowledgeable. And we got from them about 80 pages of opinions on whether or not this works. And what we wanted them to say to us was, does the way in which it's executed by this email arrangement, is this consistent with the legislation for execution of documents in a manual context? So what they had to do was look at the legislation and say, well, can we actually interpret that legislation as encompassing executions by virtual signings? And the clear response we got from our real estate counsel and also from this Mark Hapgood QC was that yes, a virtual signing using the steps set out in the Law Society formula would equate to a manual signature in accordance with the legislation. As I say, that has not, as far as I'm aware, been tested in the English courts. So I cannot give you a definitive answer that it absolutely 100% works, but we were very careful, because we knew the profession wanted guidance on this, to get some very detailed opinions from people, which gave us the assurance to put out this guidance note, which we felt would at least give practitioners and their clients greater comfort that doing these virtual signings had some legal basis. Though, as I say, there is no case law that says 100% yes, it works.
Do forgive me, and I may regret asking this question. Clearly, we're talking here about the communication method being electronic. I just kind of go back to when it was all paper and wet ink. The page upon which the signature is, which is part of the contract, how was it possible in that circumstance to know that that page related to the contract? If, for the sake of argument, as sitting here, I have a loose leaf binder where I could take an individual page out and put another one in, was there no process of initialing all the pages which were being authorised by the full signature page so that you would actually have the link when it was paper? And therefore, is there an issue there?
It's an excellent point, and call me naive and call most of my fellow practitioners naive, but I think we assumed that once the document had been physically bound, had a binder on the side, that, I mean, I've always known and always been brought up in practice that once a document has been, we call it engrossed, physically bound, that you must never unbind it. And that I think probably gave you the reassurance. Because what would happen would be the solicitor would physically engross the document, send it to the other party solicitor. The other party solicitor would check it. They would then send it to their client, bound. So it will be bound, so the signature paper will be bound in at the end. The client would physically sign it, and they would then return the bound document to the solicitor. The solicitor would then have the bound document. So yes, I agree that it is possible that the client could decide to unbind the document, to take out a few pages, put a few more in, mess it around. It doesn't tend to happen that way. I mean, people generally, if they're law-abiding citizens, are probably not going to go into that process, and they'd have no reason to start interfering with the document because the client will be relying on the solicitor to have got the document right. What I'm saying is, I think that scenario was probably a little bit more foolproof than the issues I potentially raised, which I appreciate were not brought out necessarily in the Law Society practice note, but it occurs to me as we're speaking that it's perhaps a bit more foolproof than a virtual signing scenario where there is the danger, because you are asked, depending on the client, to actually send back to you the right part. And if he's got a number of emails in his system and he accidentally just happens to attach the wrong document, one could see it happening. And I think that's more likely to be of an issue than somebody unbinding a physical document. So we knew it was the same with a physical document. It was bound into one document.
So in moving to the electronic world, we're seeking to replicate that physical relationship which requires a positive action to disrupt that existed prior to the electronic world. But as yet, there's been no legal challenge to that. I think probably we've done that to death, and I know colleagues have other questions. Convener.
Thank you very much, Stuart. Could I then move on to John Scott, please?
Thank you, Convener. Good morning, Mr. Gordon. And what are, if I may ask, the Law Society's general views on the bill and its likely impact on businesses operating in Scotland and the competitive position of Scottish law firms?
Unfortunately, I'm not an expert on Scots law, so I wouldn't have the arrogance to think that I could tell you about that. But there is one aspect, actually, that I think is worth making in an analogy to the English law context and the virtual signing scenarios that I talked about. So looking at the option 1 that we discussed just now, the English legal view is if you send through to the solicitor a signed page by the client together with the document, the views we've got from counsel, the position that we adopt, is that counts as a legally effective and binding virtual signature. And as I discussed in relation to delivery, unless you make it clear that delivery takes place other than at the date of signature, it will take place on the date that the signature page and the document is emailed to the solicitor. So with delivery, in our context, you need to make it clear that even though you've sent through your virtual signature, the document doesn't actually have legal effect until the date of the document. In the context of your bill, I think the analogy is, as I understand it, you talk about a copy of a signed traditional document being transmitted by electronic means such as emails. I think that's the heart of your bill, as I understand it from the stuff I've seen. And to my mind, that does seem to me to be quite similar to option 1, as we discussed, where the client has signed the page, they're sending the page, and they're sending the document by email. We have counsel's opinions, and we produced a note that says that if you follow the relevant option steps, the party is legally bound by that virtual signature, as I said, unless you say it's going to be on the date of the document. But for your purposes, you're legally bound by that virtual signature. And to me, that is an analogy to your bill's proposals to a copy of a signed traditional document being transmitted by email and it having binding legal effect. So as I say, I can't comment on the Scots law element because I'm not a Scottish lawyer and I'm sure I'll say the wrong thing. But in terms of the analogy to English law, I do see an analogy between the heart of your proposal and what we have in relation to option 1.
I suppose, just returning to that question, do you see any competitive advantage accruing to Scottish law firms as a result of this bill? I certainly believe that the Scottish legal firms believe this to be the case, but I'd be interested to hear of your opinion on that.
I think that if the consequence of this is that Scottish law firms do a lot more virtual signings, then they may perceive that they're doing their executions in a more efficient fashion. And if they're doing more of these executions than English firms are doing virtual signings, then perhaps they may perceive there to be a competitive advantage. But as I say, I think the way things are going now with the Land Registry saying they don't require wetting signatures, and the way that so many transactions are so overseas based, quite often cosmopolitan, I think there's a great chance that a lot more virtual signings are going to take place in the English jurisdiction. So if that is the advantage, that they're doing more virtual signings than us, I think ultimately it will balance itself out.
Thank you very much. Can I just ask you whether the Law Society has any comments on the fact that the bill does not require parties to include an express counterparts clause in contrast to the normal position in England?
Okay, so in relation to my experience of real estate documents, we don't have counterparts provisions in our documents. We simply say the part executed by the landlord is the original and the part executed by the tenant is the counterpart. And you don't need to say it's the counter. You don't need to have a 4 or 5 line clause in your document that says that it's a counterpart. It's just called a counterpart. Usually in commercial agreements, you do have a 4 or 5 line counterpart provision, basically saying that each party counts as the original and they're in identical form. But as I understand it, as a matter of law, English law, you do not need to have a counterpart clause in a commercial agreement, provided clearly the documents are in identical form.
Thank you, that's very clear. And finally, whether the Law Society has any other comments on relevant differences between the English law and counterparts and the approach envisaged in the Scottish bill?
I personally have no comments in that regard. My only comment and great interest is the concept of being able to have legal effect to a document merely by physically delivering it, which is something that we don't really have a concept of in English law, and does highlight the great and interesting differences between our jurisdictions. But I have nothing further to add on that question.
Thanks very much.
Thank you, John. I think Margaret McCulloch would like to come back.
Yeah. Can I go back to the signature page where all parties actually sign? And you says it could be sent to them electronically for them to sign, print out, scan and send back to you. Can you confirm that page, does it have a header or footer tying that page into the actual document that they're agreeing to sign, or is it a blank page?
No, it won't be a blank page. It will normally have, I mean, I can't confirm that every document I've ever seen has got page numbers, because some don't. But usually it will be, you know, if the final main part page of the main part of the document was page 56, the signature page will usually be page 57. And it will literally have on it, there'll be no, the footer will just be the document number. So that, again, I suppose, ties it into the rest of the document. There will be no header. You'll simply have the execution clause, the wording, signed as a deed by, in the presence of that. You have those words, which will then be the words that enables the client to sign in the relevant place. But the only thing to tie it into the rest of the document will be a page number at the bottom and the same document number. I agree that that is probably not quite as crystal clear as you might want it to be. You know, you might say, well, it'd be really good if we had something on there saying this is a signature page for the document to which it relates. I agree, that would be clearer. The way that we do it at the moment, I would suspect, is not as clear as that.
So is there any reason why that hasn't been done? And if it is implemented, would it make the document more secure, as in that signature is tied to that particular document and can't be used for anything else?
It hasn't been done because I don't think people perceive it to be a concern. I think if people have got lawyers acting for them, they trust their lawyers to get it right. You know, clearly if there's a fraud going on, different scenario, but that rarely happens. In most normal scenarios, the parties would have their solicitors acting for them, and they would trust their solicitors to get it right. In terms of the answer to your question, I believe having the words at the top probably would make it more secure. But actually, does it make it, what situations are we concerned about? I mean, one of the key concerns we've not really touched upon with virtual signings is the possibility that it makes fraud more likely. And if fraud is going to be perpetrated, the fact that you put 2 lines at the top of the page saying this is the document to which it relates isn't necessarily going to stop a fraud being perpetrated, because somebody can just manipulate the legislation to suit their own nefarious purposes. So I think that people trust the system. I'm not sure that my suggestion about having the lines at the top of the page would take off in our jurisdiction. People would just think it's fiddly. That is actually the first suggestion I've heard made about that idea. I've not heard it made in the English jurisdiction. From your perspective, starting afresh, looking at it anew, yeah, why not? It's a good idea. Yes, it won't stop a fraud, but it does tie the signature page better into the rest of the document. So it is a good suggestion, I think.
Okay, thank you very much.
Right, thank you. If I can bring in Stuart McMillan, please.
Hi there, good morning, Mr Gordon. Just following on from your comments a moment ago, how prevalent actually has fraud been with this particular practice that's taking place in England and Wales?
It's actually, I mean, I've not been provided with any statistics by the Law Society or anybody else as to the regularity of fraud here. It is a new practice. And I suppose the problem is that if frauds were taking place, publicly one wouldn't necessarily get to hear of it. And I might almost answer by saying that although these types of signatures have been going on for some time, it probably is too early doors to say how prevalent fraud is. It's not been highlighted in the press as an issue, although it's a concern. It's a concern because of some of the fact that anything done electronically, we just see in the press every day. There's a greater chance of hacking. There's a greater chance of fraud in that context because, well, personally, call me a Luddite, but when I've got a physical document, it's still, one feels that gives you a great, more security. Like when we used to have land certificates, it gives you more security than just relying on somebody will amend the register and there's nothing to prove it. So I'm still a believer that possibly physical documents give you that greater degree of security. So in that sense, there is a greater chance of fraud, but I don't at the moment have the stats to show that fraud is happening more often in relation to virtual signings than it is in relation to manual ones.
Have there been many reports in the media in terms of fraud cases?
In this area, I've not heard of any in relation to virtual signings. But as I say, that doesn't mean there haven't been any, but none has been reported. And I mean, I suppose if there was such a scenario, then it would presumably have the police involved, and there may be, I don't know if those kind of cases may not even be published for a time because of the investigations that are going on. So, I mean, the practice note has been out for a time now. I think what will be particularly interesting is the fact that now the Land Registry will accept certified copy documents. Remember that at the end of the day, virtual signings in relation to sale contracts are probably less of an issue than they are in relation to the actual transfers of the properties. That's where the fraudsters would really be interested. And it's only from the 30th of June of this year that the Land Registry has said we can have certified copy signatures, which lays open the possibility of having virtually signed leases or transfers effectively being sent to the Land Registry. Now, if a fraud was going to take place in that context, it is quite early because it literally was only 7 weeks ago that this went live. It's probably too early to judge if it was going to happen. But it certainly will be interesting over the next year or so to see whether we get more of these cases coming out in the press. And that really will highlight if there are serious pitfalls with the virtually signing process, particularly where it relates to dispositions of land.
Okay. Well, thank you very much.
Right, thank you very much indeed for that. We return to Stevenson on the particular issue of electronic signatures.
Yes, I've just had put back in my mind a gentleman called George Scoville, who 200 years ago broke Napoleon's Le Grand Chiffre and thus laid the groundwork for his ultimate defeat at Waterloo. So maybe the lawyers are quite correct to stay away from anything electronic requiring encryption and encoding. But I just wonder, caution, indeed. Indeed, what worked 200 years ago might still be a danger today. The bottom line is I'm really interested to know what plans or work is currently being undertaken by the Law Society or other people in the English legal system to promote the use of electronic signatures, to create an infrastructure that would allow it to more simply, cheaply and easily be introduced.
As far as I'm aware, the Law Society themselves are not actually at the moment involved in the promotion of true digital signatures. It is something that we have looked at length over the years, and many firms have written about the subject matter. Probably, for my mind, the best iteration of digital signatures actually came from the Land Registry's earlier iterations of e-conveyancing. and on that subject, I was doing a bit of research last night, actually, because I thought you might ask this, and I actually found quite an interesting article in Computer Weekly from 2008, which looked at the role of public key infrastructure systems in guaranteeing the authenticity of property transaction documents. If you go online and look at Computer Weekly 2008, you'll find it there. There was also, I noticed there was also some land registry documents from that time setting out some of their technical parameters in relation to PKI. In a nutshell, what this involved, if the land registry's proposals had gone ahead, which ultimately they didn't, was that authorised parties would be able to exchange information quickly between each other and the land registry. And what would happen there is that there'd be an encryption of the documents, and they would be signed with a digital certificate. I think this is probably what you have perhaps in mind. And for people to get into those documents, they would need a secure token, and you need a username and a password to produce and read the documents. The original plan of the land registry was for up to 300,000 documents a day to be affected this way, and that up to 500,000 security certificates would be supported. And ultimately, in that arrangement, the land registry would be managing a central authority that issued the certificates that enable parties to sign electronically the documents such as transfers and mortgages. The law firms themselves, under that arrangement, would appoint particular administrators to ensure that the people at their end were acting in a secure fashion and properly utilising these certificates, and there will be security to enable access. As I say, the system never saw the light of day in an e-conveyancing context, but if you haven't spoken to them already, it might be worth the committee speaking to the Land Registry of England and Wales so that you can maybe speak to them about their experiences. And as I say, if you don't want to do that, I did notice, if you do a search on PKI, there was a land registry, there was a sort of 10-page document which talked about some of their technical aspects of their project which may be of interest. In terms of English legislation, we have the Electronic Communications Act of 2000, and that's actually quite a wide-ranging bit of legislation in relation to electronic signatures, because it makes all electronic signatures, whether they're simple ones or advanced ones, and I'll come on to the difference in a short while, all of those signatures would be admissible in UK legal proceedings. But in terms of the evidential weight that is carried by that signature, it does depend on whether or not it's simple or advanced. So simple is something like a simple typed signature at the end of an email, which frankly doesn't carry much evidential weight because it's not very secure. The more advanced signatures that are talked about are those that are certified by some kind of certification authority, more akin to the kind of land registry, PKI protected signatures that I was just talking about. And the other problem with electronic signatures is, although we have an umbrella act in the Electronic Communications Act of 2000, it's not entirely clear that every other bit of English legislation enables that act to be used to effect electronic signatures in that context. As I say, in relation to the property legislation, we specifically went to council to get their views on virtual signings. But in terms certainly of an application of PKI infrastructure or equivalent to signatures under English law, one couldn't definitively say that every English bit of legislation allowed for that. And that was simply perhaps due to the not complete incorporation of the 2000 Act into other bits of legislation.
It's very interesting. I'll just close with an observation that the banks and the CHAPS system have been using this technology since 1982. So there is a bit of evidence that it actually works. I happen to be the project manager for the project, so I know something about it. But I think that's helpful. Thank you.
Thank you very much indeed. It does occur to me, Mr. Gordon, that we might be looking at a situation where there is a need for some internationally agreed protocol on these things. The route that we're going down doesn't seem to be reversible. Is there any indication that that's happening from where you're sitting?
From where I'm sitting in a real estate context, no, but that doesn't mean it won't happen in the future. And particularly with the transatlantic, cosmopolitan nature of transactions, it would not surprise me if that does happen in the future. But that is not an aspect that I specifically have been involved in. I'm not aware that the Law Society has had any discussions with law societies from other jurisdictions in that regard. But I agree with you that I think that that is an important step going forward.
Thank you very much indeed. Right, we now move on to electronic document repositories, and I go back to Stuart McMillan.
Thank you. Mr Gordon, what are your thoughts on the benefits which a dedicated electronic document repository could actually bring to the system envisaged by the SLC report?
Can you just be clear as to what you mean by electronic document repositories in that context?
Well, the Scottish Law Commission, in their report, they suggested that a repository was recommended, and this was on page 63 of the report, but it's not been dealt with in the bill. So just to have some type of facility where all the electronic signatures, all the electronic documents could actually be collected.
So what we have, the nearest equivalent we have of that in property contexts are, and it's usually finished documents, completed documents, we have extranets. So an extranet is what I would define as an electronic document repository, because what we do is we put all our electronic documents in one place. We usually do it for clients, and it's used on transactions, and the ease of it, of course, is moving into the virtual world. We don't want to be sending the other parties on transactions a whole ton of paper documents. So people access those documents in one place. In terms of a wider application, there have been discussions, I think, and I'm not sure how progressed they've been, possibly even involving the Land Registry, about the extent to which they could take on board holding a series of different documents in context. But I'm not sure if that's proceeded at all. I mean, ultimately, I suppose people are seeking to improve the efficiency of property transactions in our jurisdiction, I'm sure in other jurisdictions, and having ease of access to all relevant documents in an electronic context, in one electronic document repository, would be very helpful to all the parties. In terms of how far progressed that has got in a sort of public sector context with agencies, I don't think that's progressed at all, but we do use it, as I say, in a private context in terms of the way that we transact and the way that we hold documents, and that is a big thing for law firms, particularly at the larger end, where there are often big properties, lots of documents, and you want to make it as easy as possible for people to access them. So used in a private context, not used so much in a public one.
Okay, now certainly in Scotland, the Scottish Parliament passed legislation only 2 or 3 years ago regarding the land registration to actually improve the efficiency of that particular organisation and to bring it more into the electronic age as compared to the system that was there beforehand. So that certainly has been, from the SLC perspective, that certainly has been the proposal to have them as the main body to actually to collect these documents at the end.
I'm sure that it may well be that when that goes live, has it gone live already in terms of the Land Registry of Scotland?
Yes, yes.
So I'm sure that if the Land Registry of England chose to go down that route, there would be some interesting conversations.
Okay, thank you very much.
Right, I'm grateful to you, Mr. Gordon. I think that probably concludes our questions. I'm just wondering whether you feel there's anything we've missed. It seems unlikely, we've been at it for an hour, but is there any point that you had expected to come up that we've inadvertently missed, please, sir?
No, I mean, the only point actually that we didn't cover was just the options 2 and 3 on the Law Society Practice Note, which is in the context of documents that are not real estate contracts or deeds. And certainly options 2 and 3 take a more adventurous approach to the execution of documents with, in fact, in option 3, a pre-signed signature page. So what happens is you get the client to sign just a separate page, and then basically leave it to the parties to then go away and agree the document and then attach the page to the finished version of the document. Speaking as a real estate lawyer, that's not something that fills me with great comfort. And if I was a client, I wouldn't be filled with great comfort either, because I like to look at what I'm signing, to be honest. So although option 3 caters for that scenario, it would not be one that I would be recommending to people, because I think it's a very dicey way of going about executing documents, where you sign a page up front before you've even seen the document. I'm not sure how many members of the committee would be happy doing that, but I don't think I would be. But apart from that, I think we've gone through all the points.
Yeah, indeed. That seems to be where the law of agency and the law of trust actually bump into each other in commercial nonsense, one would suggest. Stuart Stevenson wants to come back.
Well, I just wanted very simply to ask whether there is a legal connection between the release of that pre-signed signature page. In other words, the process of attaching it to the document. Is there a defined process around that that involves the person who provided that signature perhaps many months earlier?
What would happen is that the solicitors would be authorised to attach the document, and I was kind of overstating in a way the adventurous of it, but it's still adventurous. But what actually happens is that when the final document is agreed, it's transmitted electronically to the party who signed it at the beginning, so they can at least look at the final version of the document, and they then email back and say, yes, I'm happy with this being attached. So although they're physically signing it at the beginning, ultimately when the final document is concluded, it's still sent to that person, and it's that sending to that person and the approval back that is the legal affixing, the legal attachment to that original pre-signed page. Though the more that you both physically and electronically separate the signature of the page, the signed page, from the actual document, the more risk, the more fraud that could potentially enter the scenario, and the more reason why I'm hesitant about that kind of process.
So we're back to the situation of there having to be a legally identifiable process that connects that signature page to the document. And I'm seeing you nodding, so I'm clearly getting it right. Thank you, Convener.
Thank you. I think that brings us to the end of this. Can I thank you very much indeed, Mr. Gordon, for your evidence to us, as I say, over an hour. Very much appreciated. We will have written down every word that you say. You will find it in the official report. Perhaps we'll make sure we send you a copy of that.
Thank you for giving me the opportunity to speak to you.
Thank you very much indeed. I think just for the moment we'll suspend this meeting just so that everybody can deal with the technicalities, and perhaps I can have a cup of tea, and we'll come back in a couple of minutes. John's just on the phone. We've got time. Let's be reasonable about it. Can we go? Thank you. Right. No points. Agenda item 3. No points have been raised by our legal advisors on the Building Scotland Amendment Regulations 2014, SSI 2014-219, nor on the Title Conditions Scotland Act 2003, Rural Housing Bodies Amendment number 2, Order 2014, SSI 2014-220. Is the committee content with these instruments, please? Thank you. Agenda item 4, instruments not subject to any parliamentary procedure. No points have been raised by our legal advisors on the Marriage and Civil Partnership Scotland Act 2014, Commencement number 2 and Saving Provisions, Amendment Order 2014, SSI 2014-218, nor on the Antisocial Behaviour, Crime and Policing Act 2014, Commencement, Scotland Order 2014, SSI 2014-221. Is the committee content with these instruments? Agenda item 5, Small Business, Enterprise and Employment Bill, and this of course is UK Parliament legislation. Under this item, the committee is invited to consider the powers to make subordinate legislation conferred on the Scottish ministers in this bill. A briefing paper has been provided that sets out the relevant aspects of the bill and comments on their effect. Does the committee agree to report to the Lead Committee that it is content with the delegated powers conferred on Scottish ministers in the bill and with the procedure to which they are subject? We are. Thank you. At this point, I move the meeting into private for agenda item 6. Don't think that requires us to do anything, so we are now in private. Thank you.